Welcome to today's program, Wellness, Introduction to Wellness Competence in the Legal Profession. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Our topic today is wellness competence, which seems to be an exceedingly broad, but at the same time, an exceedingly narrow topic for a CLE program. The main reason we are talking about wellness competence today is because California recently increased to 2 hours from 1 hour the Competence CLE credit requirement, and at the same time added 1 hour of wellness competence training as an optional way for attorneys to satisfy one of the required 2 hours of Competence CLE credit. Clear as mud? I hope I didn't lose anybody there. To clarify, California lawyers now have to do 2 hours of Competence CLE credit instead of just one, and one of those 2 hours can be by taking a 1 hour program on wellness competence. You can still satisfy the Competence CLE credit by taking 2 1-hour programs dealing with the prevention and detection of substance use or other mental or physical issues that impair a lawyer's ability to perform legal services, i.e. 2 1-hour substance abuse programs, or you can do 1 substance abuse program and 1 wellness competence program. I hope that explains what today's program is and why we're doing a program in this area. So, what is wellness competence as the California State Bar defines it? The California State Bar says that CLE programs that satisfy the new wellness competence requirement should, quote, encompass practical strategies for managing mental health, stress, and overall well-being that are tailored to the legal profession. This includes, but is not limited to, the following topics: barriers to wellness for lawyers and why there's often reluctance to seek help, fostering a culture of well-being as it relates to attorney competence through evidence-based strategies, professional burnout among lawyers, including what it is, how it impacts attorneys in and out of the office, how to spot it, and how to address professional burnout, stress management programs, which focus on building awareness of stress-related problems in the practice of law, including through topics on work-life balance, recognizing signs of stress in oneself or one's colleagues, instituting preventative measures as an individual, and developing policies within a law firm or legal department for dealing with stress-impaired attorneys, ethics and well-being, including how to balance and manage competing obligations that may implicate an attorney's professional responsibility requirements, and how enhancing personal well-being and adopting strategies for balancing life's demands can enhance the ability to comply with these obligations, stress and trauma in the legal profession, including various methods for managing compassion fatigue, developing a trauma-informed practice, and improving organizational health, physical and professional health, including programs that support self-awareness, stress management, and mental well-being, i.e. decreasing anxiety and depression and stress hormones, and emotional intelligence as it relates to the practice of law and emotional self-regulation, end quote. Of course, it isn't possible for any single 1-hour program to cover all or even most of that. And according to my wife, I have no emotional intelligence, so I wouldn't presume to lecture anyone on that. Today, we're going to focus on the following aspects of wellness competence: barriers to wellness for lawyers and why there's often reluctance to seek help, professional burnout among lawyers, including what it is and how it impacts attorneys in and out of the office, how to spot it, and how to address professional burnout, recognizing signs of stress in oneself or one's colleagues, instituting preventative measures as an individual, and developing policies within a law firm or legal department for dealing with stress-impaired attorneys, and ethics and well-being, including how to balance and manage competing obligations that may implicate an attorney's professional responsibility requirements, and how enhancing personal well-being and adopting strategies for balancing life's demands can enhance the ability to comply with these obligations. The question then becomes, how do you organize a presentation on wellness competence in a way that is compelling and that tells a story, as most good presentations do? What I came up with is to tell you my story, not because I faced extraordinary challenges such as depression or substance use disorders that many lawyers face, or because I believe I am a special case in any way, but rather because I believe I've won the game, or maybe won the lottery is a better analogy, in terms of striking a balance between my work life and my life as a human being, husband, and father. I think I made some smart choices along the way with regard to my legal career, so to the extent sharing those decision points with you might help others who are coming up to those forks in the road, that will be a benefit of sharing my story with you. I also think that now that I've crossed into my 25th year as a lawyer, it's hard to believe as I'm saying it, I have a sense of perspective on being a law firm lawyer and an in-house lawyer that I didn't have when I was younger, and once again, that might benefit those lawyers who are in the earlier stages of their careers. Don't worry though, this program isn't going to be all about me, and I'm going to talk about many other lawyers, some of whom have been in the news and, unfortunately, not for good reasons, who struggled with wellness competence in the hope that their stories will provide insights for you that can help you make the right choices for yourself as you navigate your legal career. So, let's begin at the beginning. Why did I want to become a lawyer? Unlike many of you who are watching this, I didn't have a parent or close relative who was a lawyer. I wanted to be a lawyer because I saw lawyers on TV and in movies, and I thought that it would be a great job. In my day, it was TV shows like LA Law and movies like The Firm. For you, depending on your vintage, it might have been TV shows like The Practice, Law and Order, or even Ally McBeal, or movies like Michael Clayton or Just Mercy, that made being a lawyer seem exciting, glamorous, and of course, also a way to make a good living. The joke I sometimes tell is that my two favorite TV shows growing up in the 1980s were LA Law and Miami Vice. So I was going to be either a lawyer in LA or a vice cop in Miami, and I guess it's obvious which one I chose. Query whether that was the right call. I still remember how cool Don Johnson looked in those white linen suits with fluorescent colored t-shirts, but I digress. Maybe my reasons for becoming a lawyer are similar to yours, or maybe you were driven from an early age by a desire to change the world in some way, and lawyers have the power to do that in many different ways, working in public interest, serving in Congress, serving as a judge, teaching law. One thing that was a big factor for me, as it is for most other people who become law students, is the ability to make a good living as a lawyer, and consequently, the ability to pay off the significant student loan debt that I incurred as a result of going to a very expensive college and law school. I'll talk more about this later, but it's a common thread among lawyers, including many of the ones who succumbed to the pressures associated with the practice of law in terms of developing substance use disorder or becoming clinically depressed, that the need or desire to keep working in a high-stress, high-pressure environment was seen as necessary to achieve financial success, whether that was an effort to make partner at a law firm or simply just to live comfortably, buy a house, send your children to private school. That may well describe you if you're watching this program, and I humbly suggest to you that no amount of money is worth destroying your physical and mental health, and that there are many other ways to make very good money, working as a lawyer in a different capacity or doing something else entirely. So please consider making a change if you truly don't love what you're doing right now. Now get back to drafting that brief and billing that next hour. No matter how you came to the decision to become a lawyer, one thing I don't think any of us appreciated until we started working as lawyers is just how demanding the practice of law can be in terms of the hours, the stress, the emotional highs and lows, and the impact all of that can have on your health, your relationships, and your ability to balance your legal career with the rest of your life. If we knew then what we know now, would we have chosen the same path? Other careers, such as doctors, can have similar challenges, but as we'll see later, the frequency of substance use disorder and depression among lawyers is much higher than among the general population, including other professions like doctors that you might be tempted to think have it just as bad as we do. My first stop after law school was clerking for a federal district judge in New York. Clerking was a great experience, and law clerks have way too much influence on how very important cases are decided, which is pretty awesome for 20-somethings to experience. And there isn't much to say about it here, except that for me, it added to the pressure to join a law firm after my clerkship, because judicial clerks don't make much money during their clerkship years. In fact, I was running a healthy deficit during my clerkship year when I was living in Manhattan and making something like $40,000 a year. So there were a lot of packed lunches, sharing an apartment with 2 roommates, and other sacrifices. But at least I knew that I had an offer to join the prestigious white shoe law firm of Davis Polk once my clerkship ended. In addition to paying me a top-of-the-market salary and bonus for incoming lawyers, Davis Polk also gave me a clerkship bonus that I promptly used to pay off the debt that I had run up during my clerkship year. Davis Polk also let me work as a summer associate during the summer before I started my clerkship in the fall, my second summer at the firm, which also helped out a lot financially. Most of the law clerks I met during my clerkship year had similar stories. After their district court clerkship, they were headed either to clerkships on the Second Circuit or other appellate courts, or they were joining prestigious law firms like I was. So I assume my story once again is resonating out there with many of you who chose to clerk. Why did I choose Davis Polk? Obviously, I interviewed with them on campus and they offered me a summer clerkship. The clerkship went well enough for both parties and I was offered a permanent job there. I think what's important for our discussion today is that I chose Davis Polk in part because it has a reputation as being more of a lifestyle law firm than other prestigious New York law firms such as Cravath or Wachtell. At the time, there were a handful of prestigious law firms that were seen as offering better working conditions, nicer people, fewer billable hours, and a healthier culture than the hardcore firms. Among this group when I was coming up in New York were Davis Polk, Simpson Thacher, Cleary, and Debevoise, and I chose Davis Polk. I thought at the time that I was making a smart choice. I would get all the benefits of a prestigious law firm, top of the market pay, the chance to work on cases that I would read about in the Wall Street Journal, and the cachet value of a name that was on par with where I went to college and law school, while not signing up to work myself to death for people who were mean, condescending, or had unreasonable expectations. Overall, my experience with Davis Polk over the 7 years that I worked there turned out to be mostly what I expected. But the notion that it was a lifestyle law firm where you didn't work that hard, where there weren't unreasonable demands or unreasonable people, wasn't true. I'll talk a bit more about my Davis Polk experience shortly, but for now, and I doubt this will come as a surprise to many of those of you who are working or have worked at large law firms. Law firms are really tough places to work. This is true from the top tier to the bottom, in every city, not just in New York, Chicago, or DC, and in every practice area from litigation to corporate to tax to benefits. If you sign up for a tour of duty at a law firm, you most likely are signing up for a high workload, high pressure, and high stress environment. And so you can think of the hopefully large salaries and bonuses you're earning to some extent as hazard pay. To prove my point that there is no such thing as a lifestyle law firm, firms said to be in this category have had their share of horror stories about lawyers whose lives ended tragically, due in part to the demands they faced at their law firms. As I was entering law school in 1994, Charles Ford McKenzie, a promising 1990 graduate of Yale Law School who had been practicing for 2 years at Cleary, leapt off the roof of an 18-story hotel. Here is a snapshot of Charles's story, quoting from a Washington Post article at the time. Quote, "The coroner blamed his death on massive blunt trauma. His parents, however, saw an underlying cause, the law firm itself. They sued the firm, Cleary, Gottlieb, Steen, and Hamilton, saying that in the intense competition for lucrative partnerships, the firm had made impossible demands of their son, leading to his humiliation and breakdown. He was set up by being overworked," his father, Gene, said. "He was spending 20 hours a day at the office, couldn't go home at night." The suit, citing the intentional and outrageous conduct of lawyers at the firm, has drawn widespread publicity in the legal press and contributed to a long-standing debate in the profession. Do firms drive their young associates too hard? What is the toll? Mackenzie's father and friends say this was a man who had no history of mental illness, depicting him as just one of thousands of young lawyers struggling to rise to the top of their field. Charles exemplified the problem of a large law firm that tries to extend its attorneys' performances beyond all human boundaries, said attorney W. Robert Curtis, whose firm filed the Cleary suit for the parents. It's a heightened problem in New York City, which is even more fierce and more combative than places like Washington, Curtis said. But the underlying process of moving associates along and working these unbearable hours, testing their mettle, is done universally. It's part of the overall system. Mackenzie's widow, Janice, a former New York schoolteacher, said she tried repeatedly to persuade Mackenzie to leave Cleary and return to Memphis, their hometown, where he could practice law at a slower pace or follow his dream of becoming a teacher. But her husband, his hopes set on a coveted and lucrative partnership, could not walk away from the prestigious firm. The whole idea, said Janice Mackenzie, who married Charles while he was at Yale, was that we were just going to go there, and when it wasn't fun anymore, we were going to get out. Then things changed. He just told me that it was something you couldn't understand. Once you got sucked in, it was like a black hole. End quote. We'll talk more about Charles's case a bit later, because I think it speaks directly to many lawyers who are at risk of doing harm to themselves, arising from a sense of hopelessness over an inability to find a work-life balance. Another, more recent and equally awful example is from my firm, Davis Polk. On June 5, 2017, Kirti Kapoor, a corporate partner in the firm's Menlo Park and New York offices and head of the firm's India group, died after intentionally walking in front of a train in San Mateo, California. Kirti joined Davis Polk in 1999, 1 year after I did, and became a partner in 2007, 2 years after I left in 2005. I didn't know Kirti well, but when something like that happens to a peer and colleague, it definitely causes you to say, "There but for the grace of God go I." Even those of us who worked at Davis Polk don't know what caused Kirti to take his own life, but suffice it to say, it proves that there can happen to any lawyer, even those lawyers who attain the holy grail of partnership at a prestigious law firm, and at any law firm, even law firms like Davis Polk that are often viewed as lifestyle law firms, and in any personal circumstances. Kirti was happily married with a young daughter. At this point, I'd like to use my experience as an associate at Davis Polk as a vehicle for discussing our first subtopic today, which is professional burnout among lawyers, including what it is, how it impacts attorneys in and out of the office, how to spot it, and how to address professional burnout. By the end of my 7-year stint at Davis Polk, I was suffering from professional burnout, and the solution I chose was to leave the firm and take a job as an in-house lawyer. That's a common choice among law firm lawyers, and it was the right choice for me for reasons I'll cover off later. But for now, let's focus on the professional burnout that many lawyers like me have experienced in a law firm environment and what some of the causes of it might be. First and foremost, the pressure to bill a tremendous number of hours each year that most law firm associates feel is a key cause of professional burnout. If you are at a law firm where most associates bill north of 2,000 hours a year, and many law firm associates bill much more than that, I don't know how you escape professional burnout, primarily because at those levels of billable hours, your work life necessarily crowds out almost everything else: your family life, your friendships, your fitness routine, your hobbies, your travel plans. There are simply not enough hours in the day or in the year to find time for these other activities when you are billing so very many hours. The other problem is that you don't control your schedule when you work at a law firm. So in addition to billing so many hours, you can be required to work on any day and at any time, which makes it even worse. That wonderful vacation you have planned and have looked forward to for months can vanish in an instant due to a client emergency. Even if you love the work, and I certainly met people at Davis Polk who absolutely loved what they were doing, billing that many hours is simply too much for most people, myself included. If you merely liked what you were doing, which described me for the most part during my time as a litigator at Davis Polk, the pressure to bill that many hours is going to make it that much worse. So, if you're under pressure at your law firm to bill more hours than you think you can or should and maintain time for family, fitness, travel, what can you do about it? Here is where my experience may be dated, and I hope there are other potential solutions available to law firm associates now than I had back then. But in my day, there really were only 4 options. First, you could try moving to another law firm where you might feel less pressure to bill hours. Among my litigation colleagues at Davis Polk, one option some took was to join a boutique litigation firm in the hope that it would afford them a similar experience in terms of legal work, but a better lifestyle. I never seriously considered this option for myself because I had heard that most boutique litigation shops didn't actually afford their associates a better lifestyle. With fewer lawyers to call upon, the constant drumbeat of client emergencies and new matters that had to be jumped on right away meant that the lawyers they had were as overworked as we were at the large law firms, and you were getting paid less at the boutique firm than at the large firm, so you ended up worse overall. Second, you could take advantage of the law firm's part-time program, where you worked a reduced number of days or hours in return for reduced pay. Historically, the part-time track had been used by women who had taken some time to have or raise children and were looking to return to the firm but couldn't do so full-time. But in more recent times, it has been made available to anyone in the firm who is looking to make a change. While it sounded good in concept, in my experience, the part-time program at law firms didn't deliver the goods in terms of providing lawyers with a reduced workload. Many of the litigators with whom I worked at Davis Polk, who were in the part-time program, seemed to work as much or almost as much as the rest of us while receiving about half of the pay. The other concern with taking advantage of the part-time program at law firms is that doing so means you are stepping off the partner track, which is another reason it was seen as undesirable. To Davis Polk's credit, the firm actually elevated a couple of people who had been in the part-time program to partner in the years that I was working at the firm, which went a long way to dispel this notion about stepping off the partner track. But the fact that these part-time lawyers were working too hard for the reduced pay they received was still true. Third, you could stay with your law firm, but transfer to another department or office within the firm in the hope of finding a better work-life balance. This was something I did. In my 5th year, I transferred from Davis Polk's New York office to its new office in Menlo Park, California, and it certainly helped with my burgeoning professional burnout, but it was not a panacea. While I had a better work-life balance living in California than I had had in New York, I was still billing a large number of hours, and I now had a long commute on top of my work schedule that I never had when I was living and working in Manhattan. Plus, about 6 months after I moved to Menlo Park, I was staffed on a huge M&A litigation matter that consumed nearly all of my time. I had a memorable stretch where I went 6 months without a single day off, culminating in a 3-week trial in Delaware Chancery Court, where I lived out of a hotel in Wilmington and did nothing but work nonstop for about 2 months. We won the trial, and the case was a great professional experience, but my point is that moving to Davis Polk's California office was not enough to rescue me from the professional burnout I was experiencing due to the pressure to bill so very many hours. The fourth option, and again the one I ultimately chose, was to leave Davis Polk and to take a job as an in-house litigator at NBC Universal in Los Angeles. That proved to be the solution to my professional burnout as a lawyer and was the key step I took that kept me in my right mind and still working in the law. Apart from the pressure to bill a large number of hours, what else causes law firm associates to suffer from professional burnout? Another prime cause is the pressure that many law firm associates feel to make partner, or at least to remain on the partner track while they are working at a law firm. Some associates who come to law firms decide early on that they don't want to be a partner at the firm and instead are going to spend a few years at the firm getting some good training, making some good money, and networking, and then they plan to use their law firm experience to get them their next role, perhaps as an in-house lawyer or as a lawyer at another law firm, or maybe moving to the business side and not doing law at all. I had friends at Davis Polk who chose this path, and in general, I think they were a lot happier because they had made the decision not to run on the hamster wheel that the rest of us were on because we wanted to be law firm partners, or at least we wanted to have the opportunity to be made partners, and didn't want to be thought of as someone who didn't want that. At Davis Polk, and I suspect at most other prestigious law firms, most associates in each class are on the partner track, or at least they don't want to be seen as not on the partner track. Now, the reality at most firms was that only a few of the associates that enter each year are going to be made partners. At Davis Polk, it was something like 8 or 10 partners in each year versus the approximately 100 associates who start each year. So you are facing pretty long odds right at the jump. You can convince yourself that your odds aren't really that bad, because by the time partnership decisions are made in your 7th or 8th year, there might be only 10 or 15 associates left in your class due to all of the attrition. But the bottom line that it is very difficult to make partner at any law firm. This is before you consider any of the other factors that you simply cannot control. For example, if you come up for partner during an economic downturn, your odds go down a lot. Or if you work for a single client and that client gets taken away by another law firm, your odds go down a lot. All of this can scuttle your partnership chances, just as you're nearing the finish line after a race that you've been running for nearly 8 years. So if law firm associates face such long odds of making partner, why is nearly everyone at law firms on the partner track? For my part, making partner at a law firm was just the latest hurdle that I was attempting to leap over in my long academic and professional career. I was driven to do well in high school to get into a good college, to do well in college to get into a good law school, to do well in law school to get a good clerkship, and finally, to do well at a law firm to make partner. Most lawyers are type A and probably look at a law firm partnership the same way that I did. It was yet another credential I wanted to earn. Apart from that, when you're working at a law firm, you see the many benefits of being a partner. These are powerful people, both within the law firm and in society generally, who make a lot of money and who are given a lot of respect, so who wouldn't want to be a member of that club? I remember one M&A deal I worked on where our client was a major investment bank, and we dealt with some masters of the universe type MDs who were rich and had tremendous power. But I also remember that when it came time to negotiate key parts of the merger agreement, it was the senior corporate partners on both sides of the deal who were the masters in that domain. And I thought that was pretty cool. Even these really rich and powerful people had to defer to Davis Polk partners when it came to important issues in the legal domain, which was a testament to the power of these law firm partners at prestigious law firms. There is a dark side to law firm partnership that I will talk about next, but I don't think many law firm associates would say they wouldn't rather be a partner than an associate. Lest you think my experience or point of view on law firm partnership is atypical, let's return to the tragic case of Charles Ford McKenzie that I mentioned earlier. Charles was driven and ultimately trapped by his desire to make partner at Cleary and his refusal to leave even when his job clearly was making him miserable, and that is not an uncommon situation. Of course, Charles's case is tragic because it is rare that a lawyer commits suicide, but that feeling of hopelessness Charles experienced because he felt trapped in a law firm job, I think is common to many. I'd like to share a bit more of Charles's story to see if it resonates with you. Quote, McKenzie started in the corporate department at Cleary, working on financial transactions. As he became more senior at the firm, his hours grew longer, and his wife, Janice McKenzie, said she saw him less. According to the suit that his wife filed against Cleary after Charles's suicide, he began to complain about the stress of his workload. He became irritable and restless, telling his father that in the first 6 months in 1991, he had worked about 1,500 hours overall, about twice as much as other associates. The lawsuit alleges that in October 1991, McKenzie, who was by then reaching the point of total exhaustion, was told by an unidentified colleague that 2 senior lawyers, acting out of malice and to teach him a lesson, had given him more work than he could ever complete in the required time, work that demanded greater competence than he possessed. According to the lawsuit, McKenzie was devastated, telling his wife he felt tricked, no longer secure at the firm. He became suspicious and was unable to sleep, believing that lawyers at the firm wanted to make him a back office boy by wearing him down to the point where he would lose his ambition. He became depressed and told family members he was convinced lawyers were trying to drive him out of the firm. On Saturday, October 26, there was a dramatic confrontation at the law firm as Janice McKenzie showed up and interrupted a meeting of some of the partners. A note was sent in, and Gorin and another senior lawyer who supervised junior attorneys were called out. According to Gorin, Janice McKenzie said her husband thought he was going to be fired. Gorin said he told her that wasn't true. There's obviously some huge misunderstanding. They went to the McKenzie's apartment, where they found Chuck nervous and crying. They convinced him to go with them to an emergency room, where he was seen briefly by a psychiatrist. Gorin said his impression at the time was that McKenzie's problems were personal, not work-related, and he was given a paid leave of absence. But Janice McKenzie, according to the suit, sensed a lack of sincerity or any concern for Chuck by Gorin and the other lawyer, and said recently that Chuck just had this look on his face the whole time, "I hate you people." Over the next 3 months, McKenzie spent time between Memphis and New York. When he was with his family, he seemed to improve. When he returned to the office, even after transferring to a new department, he seemed to worsen, according to the lawsuit. McKenzie felt branded and insulted when attorneys prefaced new work assignments with questions about whether any particular assignment was too much for him. On January 25, 1992, while stopping over in Charlotte, North Carolina, on a flight back to New York, he was found passed out from intoxication in an airport lounge and taken by medics to a local hospital. He showed up again at the airport the next day and was arrested for being intoxicated and disruptive in public, according to a police report cited in court records. He was detained overnight. After his release, McKenzie checked into a Marriott and around 2 p.m. rushed to the roof where, as the Charlotte Observer reported the next day, he was found by 2 security guards. They called to him, and for an instant he stepped back. Then he took a running dive. End quote. This is a truly awful story. In the hope that discussing it will help other lawyers, and without pretending to know exactly what was going on in Charles's head, I'd like to comment on a few things that struck me. First, the fact that as Charles became more senior at the firm, he began working more and feeling more pressure is really important. Speaking from my own experience at Davis Polk, when you are a brand new lawyer at a law firm, your life is pretty good. Yes, you are working a lot, but your overall stress level generally is pretty low. That is because when you are a very junior lawyer, you are, for lack of a better word, fungible. By which I mean that you or any one of your 100 or so colleagues can be asked to do roughly the same work. Someone needs a legal research memo written or some documents reviewed in a diligence room or a deposition transcript summarized. A partner grabs one of you, gives you the assignment, you complete it, and then you wait for your next assignment. Your only real source of stress is when you get that call or text or email from a partner with those 3 little words that can change your life, which is not, "I love you," but rather, "How's your time?" The point is that you get an assignment, you do a good job on it, and you wait for the next one. You don't have overall responsibility for the matter or the client, or for anything else for that matter. That responsibility falls on the senior associates and the partners, and this is why the level of stress steadily increases as you move up the ladder in a law firm. If you're a senior associate and you ask a junior associate to research and write a legal memo on a topic, if the junior associate does a bad job, guess who has to redo the legal memo? You do. You are also expected to become the intellectual engine of your matters, deciding in a litigation, for example, what motions should we file, what depositions should we take, such that you are the one who is driving them along and who is responsible for making sure everything is done right. So, unless you are an associate who has expressly taken him or herself off the partner track, every year that you spend at a law firm will involve more responsibility and more stress than the year before. This is true of junior partners as well. They are probably the most stressed out of anyone because they have responsibility for everyone who works on the case, and they answer to the more senior partners who own the relationship with the client. This is the dark side of law firm partnership that I alluded to earlier. It's no longer the case that once you make partner, you have it made and can simply relax. On the contrary, junior partners are even more trapped than associates. Not only are you responsible for everything that happens on your matters, so your stress level is higher than when you were an associate, now you really can't leave the firm because you'd be walking away from a partnership that you spent the last 8 years working your butt off for. You'd be walking away from all that power and prestige, and of course, all of that money. You've probably become accustomed to that money, the nice house or houses, the nice cars, the kids in private schools, and so it would be particularly hard to leave it behind. Maybe things would be better at another law firm, So you finally end up returning the calls of that headhunter who's been chasing you to switch law firms. But guess what? You can't move to another law firm as a partner unless you can bring most of your clients with you, your so-called portable book of business. If you have a portable book of business that generates $20 million in annual billings, you can move to another law firm as a partner and even be given a nice guaranteed salary for the first few years. But if you don't, you're stuck where you are. If I had stayed at Davis Polk and made partner but then wanted to leave, what are the chances I could have taken JP Morgan Chase, Deutsche Bank, or any of the other clients on whose matters I worked with me to another law firm? 0. Those are all institutional clients that Davis Polk has been representing for dozens of years. Indeed, John W. Davis, the founder of Davis Polk, actually represented JP Morgan, so that client isn't going anywhere. My only choice at that point would have been to go in-house, where I likely could have secured a job as a general counsel, but I wouldn't have had the option to make a lateral move as a partner to another law firm. The other sad fact about law firm partnerships is that they don't get much better as you become a more senior partner. In the old days, as partners became more senior, they would move into a rainmaker role, where their primary job was to bring in new clients and keep the clients they already had happy, as opposed to actually working on their matters. In those days, senior partners spent more time on the golf course than in the office, but those days are long gone. When I was at Davis Polk, I worked closely with senior partners in their 60s and 70s who were billing north of 2,000 hours a year. For some, it was peer pressure that drove them to bill so many hours, and for others, they loved the work so much that they would do it for free. That is why I say the latter are the only people who should be law firm partners. If you love the work so much, you would do it for free. For everyone else, the money doesn't make it worth the sacrifice. And in some cases, chasing that money ends up making lawyers so miserable that they end up like Charles. So when I read that Charles was working more and feeling more stressed out as he became more and more senior at Cleary, it resonated with me, and I wish that Charles had felt that he could have done something to get out of that situation. It's ironic that even if Charles had made partner, I don't think he would have felt any better, and very likely, he only would have felt even more hopeless and trapped in his situation. Let's turn now to our second big picture topic for today's presentation, which is recognizing signs of stress in oneself or one's colleagues, instituting preventative measures as an individual, and developing of policies within a law firm or legal department for dealing with stress-impaired attorneys. The other things that struck me about Charles's story were that he was seen by a psychiatrist after he was taken to the emergency room, and later was given a leave of absence from the firm. While we don't know if Charles was diagnosed with clinical depression, there certainly were signs there. There is also a reference to Charles being intoxicated and disruptive in public a few days before he died. The other thing that leaps out is that after Charles returned to the firm, he felt that he was being stigmatized because he had taken a leave of absence for medical reasons. This is the main reason that lawyers don't seek medical help in cases where they might be suffering from clinical depression or substance use disorder, and thus might benefit from treatment that includes, in many cases, therapy, but also medication. If there is a bright side to Charles's story, it is that some 30 years later, I have two very different stories to share with you. The first story is that of Joe Milowick. Joe is a partner at the very prestigious law firm of Quinn Emanuel, who has been very open about his struggle with clinical depression and has been a great example for any lawyers who are concerned about the stigma of mental health such that they don't seek the help that they need. Joe is also a founder of the Lawyers Depression Project, LDP, which is a grassroots project aimed at addressing depression and other mental health issues in the legal profession. The LDP is comprised of attorneys, law students, law school graduates, and others in the legal field who were diagnosed at one point or another in their lives with major depression, bipolar disorder, obsessive compulsive disorder, general anxiety disorder, or another mental illness. Joe was able to overcome his struggles with mental health, and in being so open about it, he has helped countless other lawyers avoid the fate that Charles suffered. The second story is that of Jim Heiting. After causing an accident in which a woman was killed because he was driving under the influence of alcohol, Jim went into recovery for substance use disorder, and in the decades since then has helped hundreds of other lawyers get help, including by arranging and participating in interventions at the request of friends and colleagues who sought help for other lawyers. In addition to achieving personal success helping others get help, and professional success in his career as a litigator, Jim also rose to the position of president of the State Bar of California, where he was able to use that platform to further raise awareness of substance use disorder among lawyers. Throughout his career, Jim has been a tireless advocate for substance use disorder awareness and training among the legal profession, partnering with a wonderful organization known as the Other Bar. While this is not a presentation on the prevention and detection of substance use or other mental or physical issues, there are a great many programs devoted to that topic. The stigma that lawyers associate with mental health and substance use disorder is a critical reason that many lawyers who are miserable in their law firm jobs don't seek help, so we should talk about it here. Knowing how to identify the common symptoms of depression is an important step toward getting help. Typical signs of depression include depressed mood that may present as feeling sad, empty, or hopeless, a noticeable decreased interest in activities that were once pleasurable, eating too much or too little, sleeping too much or too little, fatigue or loss of energy, trouble concentrating or trouble making even basic decisions, thoughts of harming yourself. Depression is more than just ordinary sadness. Sadness that is a symptom of depression doesn't have a specific trigger. You simply feel sad or hopeless about everything. Also, thoughts of self-harm don't arise from non-depressive sadness. With regard to substance use disorder, there are many tests that lawyers can use to see if they or others they know might have a problem. One such tool are the CAGE questions, and it's a useful screening tool for problematic drinking. A yes answer to 2 or more of these 4 questions is a sign of a problem. C stands for attempting to cut down. A is whether the person gets annoyed by criticism for drinking. G is whether the person has ever felt guilty about drinking. E stands for eye-opener, for example, morning drinking. This is an easy-to-use and important tool to keep in mind when you are thinking about your own situation and what you might observe among your colleagues. Just how prevalent are depression and substance use disorder among lawyers? Focusing first on depression, in 2023, the California Lawyers Association and the DC Bar shared findings from a groundbreaking research project offering insight into personal and workplace risk factors for mental health problems among practicing attorneys. Using a random sample of approximately 2,000 practicing lawyers from California and Washington, D.C., the study examined the relationship between thoughts of suicide and various factors that negatively and disproportionately affect lawyers, including perceived stress, loneliness, work overcommitment, work-family conflict, alcohol use, and prior mental health diagnosis. The study's key findings were, quote, lawyers were twice as likely as the general population to experience suicidal ideation. Perceived stress was the #1 predictor of suicidality. Compared to lawyers with low stress, those with high stress were a remarkable 22 times more likely to experience suicidal thoughts, and lawyers with intermediate levels of stress were 5.5 times more likely. Lonely lawyers were nearly 3 times more likely to have suicidal thoughts, and those who are highly overcommitted to work more than twice as likely. Male lawyers were twice as likely to contemplate suicide, a notable difference from the general population where women experience higher levels of suicidal ideation. Prior mental health diagnosis also increased risk of suicidal ideation. A significantly greater proportion of lawyers who contemplated suicide indicated that working in the legal profession was detrimental to their mental health and contributed to their substance use and feelings of burnout, end quote. Turning to substance use disorder, there are 2 key studies in this area. The first was conducted in 1990 with a survey of 1,200 lawyers in Washington state. That study found that the rate of problematic drinking among lawyers was 18% versus 10% among the general population. The study also found a significantly higher than expected rate of depression among the participants, which was confirmed by the study I referenced earlier. In 2016, a larger study of 13,000 lawyers from multiple states pegged the rate of problematic drinking closer to 21%, and therefore approaching 2.5 times the general population. Tellingly, in case you believe these numbers reflect the stress of the job or personality types drawn to the law, the prevalence of problematic drinking among doctors, based upon studies done in 1990 and 2012, was steady at roughly 15%. In practical terms, this means that statistically, 1 out of every 5 lawyers you know has a drinking problem. What can law firms, companies, and other organizations do in response to these sobering statistics about depression and substance use disorder among lawyers? The 2023 study offered the following recommendations. Quote, a twofold strategy whereby stressors in lawyers' lives are reduced and their stress tolerance is enhanced would seem to be the most efficacious approach for mitigating the stress suicidality risk in this population. Considering the profound impact of stress on lawyers' suicidality, all options should be considered for mitigating stress, including an examination and recalibration of attitudes, norms, and cultures relating to their work. Employers may be able to help mitigate some of the loneliness their lawyers experience by making collaboration and regular social interactions in the work environment more of a priority. Given the high rates of alcohol misuse among lawyers, efforts to combat loneliness and isolation should avoid reliance on alcohol-based events as a primary means of increasing socialization and connection. By raising awareness of the notable downsides of being too committed to one's work, encouraging lawyers to set appropriate boundaries in their lives, and reframing notions of success, the legal profession may be able to temper the harmful effects of work overcommitment. End quote. It's been over 10 years since I've worked in a law firm, so I won't pretend to opine on whether law firms have adopted any of these recommendations. All I can say is that as compared to 10 years ago, the awareness of mental health and substance use disorder among lawyers is much higher now, which of course is a good thing. The challenge is that client demands, the pressure to bill thousands of hours a year, and the desire to secure a coveted spot as a partner haven't changed at all. At least lawyers and law firms are talking about these issues, which never used to happen, and the stigma associated with seeking help has been greatly reduced. As I said, this is not a presentation on the prevention and detection of substance use or other mental or physical issues, but this information is just so important for lawyers to have, particularly when we are talking about recognizing signs of stress in oneself or one's colleagues and instituting preventative measures, because depression and substance use disorder are frequently reactions that lawyers have to being in stressful environments for long periods of time. Let's turn now to our final big picture topic, ethics and well-being, including how to balance and manage competing obligations that may implicate an attorney's professional responsibility requirements, and how enhancing personal well-being and adopting strategies for balancing life's demands can enhance the ability to comply with these obligations. Your ethical obligations are set out in ABA Model Rule 1.1, entitled Competence, which provides that, quote, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation, end quote. Of course, lawyers who are suffering from clinical depression or substance use disorder may be at risk of violating their duty of competence. That said, state bars are reluctant to bring disciplinary cases against lawyers on that basis if the lawyer has sought treatment for his or her condition, which is sensible because we want to encourage lawyers to get the help they need. There are many cases, however, where disciplinary charges were sustained against lawyers, where substance use disorder or clinical depression played a role, but that involved very serious underlying offenses, such as misappropriating client funds. Beyond those cases, lawyers who are overworked and overstressed to the point that they believe their bodies are failing them could run the risk of failing to provide competent representation. In my experience at Davis Polk, no stone ever was left unturned, and no detail ever was ignored, so the risk that any one of us was failing to provide competent representation under ABA Model Rule 1.1 didn't come into play. In fact, we were killing ourselves to provide outstanding representation to our clients. The clients were paying the bills for that representation, and we were paying our own price in terms of our physical and mental health. For me, the only way I could balance my job as a lawyer with my personal well-being was to leave Davis Polk and to take a job as an in-house lawyer at NBC Universal in Los Angeles. I already was interested in working as an in-house lawyer. When you're at a law firm and you see how much better it is to be a client, it's a walking advertisement for becoming an in-house lawyer. But I won't pretend that having a lower workload, less stress, and more predictable schedule weren't the primary reasons behind my decision. While I made a lot less money, particularly at first, I have never regretted my decision to move in-house. For the first time since I was a very junior lawyer at Davis Polk, I felt that I'd had a good work-life balance between my job and personal life. I was able to resume my hobbies, get myself back into good physical shape, take truly relaxing vacations, and develop a healthy social life. As if I scripted it from this presentation, I met my wife, who was also working at the time at NBC Universal, when I helped prepare her to sit for a deposition in a case I was handling. We're now more than 12 years into a very happy marriage, and we have 2 wonderful daughters, so I'm very grateful for all of that. I shudder to think whether I would have found any of that personal happiness had I stayed at Davis Polk. One area where I'm convinced I would not have fared as well if I had stayed at Davis Polk was my physical health. While I was still in my 30s when I was at Davis Polk, I already was showing signs that law firm life was really bad for my health. I was 40 pounds heavier than I am now, mostly because I couldn't find the time or energy to work out regularly when I was working so much. As a result of being heavier, I had high cholesterol and I was taking statins to lower it. I also experimented with some fad diets like Atkins to try to slim down, which, if you've ever tried something like that, where you only eat eggs, meat, and some vegetables, but no milk, bread, cereal, or other carbs, you know that it isn't sustainable. Even when I was on Atkins and had lost a lot of weight, I would get winded climbing a flight of stairs because I only dieted, I never worked out. I also couldn't help but view binging on food or alcohol as a reward for working so hard because those things gave me pleasure and helped to relieve some of the stress. I remember vividly sitting at my desk one Sunday night. Usually I would come in around lunchtime on Sunday and work until 10 or 11 o'clock at night, just so I could have Saturday mostly off from work, stressing over some brief emotion, running my fingers through my hair, seeing a few hairs fall out in my hands, and believing that all of my hair was going to fall out if I kept this up. Maybe my hair was starting to fall out due to the stress I was under, but it's just one of those memories that I have that caused me to realize that this was not healthy, and that if I stayed at Davis Polk for many more years, I was going to end up fat, bald, and maybe even dead from a heart attack or some other health condition I could have prevented with a better diet and some exercise. I don't want to be overly dramatic, and I share this only to say that there are warning signs when you are doing something that isn't healthy for you, and I would encourage everyone not to ignore those warnings. Fast forward to today. I'm in the best shape of my life. I have a wonderful family. I like what I do, and I have time for hobbies, travel, and many other things that I enjoyed and that enriched my life. I don't think I would have any of that if I had stayed at Davis Polk, based on the trajectory I was on at the end of my time there, and also what I imagine my future could have been like had I chosen to make Davis Polk my career. Now, I don't mean to suggest that going in-house is for everyone or that it is a panacea for all that ails law firm lawyers. All I can say is that it was the right choice for me and that I don't regret that decision. What I do suggest is that if you are in a law firm and you are miserable, that you make a change that is right for you. Maybe that is going in-house. Maybe that is going back to school to get an MBA, or maybe that is doing something else entirely. The purpose of a wellness program is to help you identify some of the reasons why you might not be as happy working as a lawyer as you could or should be, and to suggest ways to improve your situation by making meaningful changes to improve your work-life balance if you can within the confines of your current role, or if you can't, by making a change that involves you doing something else. What you should not do is keep your head down and keep plugging away even if you hate it because you think it will get better on its own or because you don't know what else to do. That's what Charles and Curti did, and we don't want your story to end like theirs did. Both to prove that working as an in-house lawyer isn't a panacea and that I am not dumping unnecessarily on law firms, I don't mean to suggest that in-house lawyers can't be overworked, stressed out, or at risk of becoming clinically depressed or developing substance use disorder. Let me share two more stories with you. The first is from an in-house lawyer at a Fortune 100 company, as retold by Joe Milliwick in a recent presentation. Quote, "For most of my life, I have been a caregiver to family members impacted by mental illness. My mother was bipolar and hospitalized numerous times for psychotic, manic episodes. She lived a very poor quality of life and unfortunately passed away at a young age. My daughter has dealt with anxiety for most of her life. However, she received treatment and medication at an early age and is thriving in college as a straight A student. I am actively involved in trying to help those who deal with mental illness and was recently appointed by the State Supreme Court to the State Lawyers Assistance Program Board of Trustees, where I am privileged to have the opportunity to help lawyers who are struggling with mental illness, addiction, and related issues. In terms of in-house counsel, while we don't have the billable hour stress associated with private practice, we are still on 24/7. I get emails and texts all day and night that require attention. We make high-stakes decisions and important calls every day. Most of my decisions impact millions of dollars of revenue each day. I observe stress and anxiety across my friends and colleagues who work in-house, and I actively work to try and deal with those issues in my own life. Fortunately, I have flexibility in my schedule to allow for work from home, to exercise, to catch up on sleep, etc., and ensure I am living a healthy lifestyle." End quote. The second story is from an in-house lawyer at a small to medium-sized enterprise, an SME, who works largely from his home office, once again retold by Joe Milliwick. Quote, "First, there is a sense of isolation working as an in-house attorney. Typically, working for an SME, you may be the only person in the company in a particular legal position. The sense of isolation results from a lack of peer support, for example, for advice on thorny issues, unlike the situation in a firm, a lack of connection with the wider legal profession, a feeling of being underappreciated. In-house legal work can be esoteric and irrelevant to virtually every other employee of the company. The personal satisfaction of doing a good piece of work is merely personal. Other people at the company don't particularly care or understand. And lawyers tend to be paid more, so there is a sense that I'm doing work which has little value in the eyes of most colleagues, and yet I am being paid more than them. Second, responsibility is the other big thing, and combined with the sense of isolation, led to my more depressive episodes. As an associate in a firm, I found contentious cases interesting or challenging. You win and lose cases, and that's life. But as a sole in-house practitioner, I felt more personally invested in everything. The management put huge trust in me to make the right decisions. The consequences of losing a litigation I was managing were more profound. The company could go under, and hundreds of colleagues could all lose their jobs. Ultimately, I became unable to separate work from home. This is a problem with technology, allowing us to read emails day and night, a problem that's not unique to lawyers, and the level of personal responsibility I felt for a litigation that felt out of my control. I went to bed fretting and woke up fretting. So I suffered from insomnia, which just exacerbated everything. I was also drinking too much, seeking an escape. It goes without saying that working long hours, stress, not sleeping, and drinking too much did not make for a happy home life. Eventually, too late, I saw a doctor because the insomnia felt like it was killing me. His advice was to exercise. It's a no-brainer, but hearing that advice from a doctor was actually helpful. I took up cycling, and it has helped with the sleeping, my drinking, and my mood generally. It's not as if exercise has solved everything, but it has definitely made things better." End quote. The in-house lawyer at the SME also offered the following sage advice for other in-house lawyers. Quote, "Number 1, make time in your life for some exercise. Don't sit in front of your screen eating a sandwich at lunchtime. Go walking for an hour at lunchtime. Cycle to work. It sounds so obvious, but the difference it makes is real. Number 2, don't isolate yourself as an aloof corporate lawyer. Most people at my workplace are not corporate people. They work on interesting projects. They work in teams. They are extremely clever. They have funny stories to tell. They have personal problems to share. They can be trusted. They are, to their credit, not lawyers. I don't think it's good enough to say my office door is always open. You need to actually walk outside your office and chew the fat with people. They won't come to you because you're the corporate lawyer." I find that not only does it help with that sense of isolation, but it helps you to do better work and give better advice. The more you understand the company and the people who work there, the more connected you feel, the better job you can do, and heaven forbid, the more appreciated you are." End quote. I would echo that advice for any of my fellow in-house lawyers who might be feeling stressed or isolated. With that, we've reached the end of our time today. I hope you found our discussion helpful and that at least some of my advice will prove helpful as you strive to manage your mental health, stress, and overall well-being. At a minimum, you've earned 1 hour of wellness competence credit you can put toward your annual CLE requirements, and so at least that's one less thing you have to worry about. I hope you enjoyed today's program, and thanks for joining me.